Assalamualaikum warahmatullahi wabarakatuh. Now we will be hearing the arguments presented for the case of Mr. John and Aminah. Today is 15 November 2022. The facts of the case are as follows. The defendant, Aminah, was driving a Honda City on the Duke Highway in the afternoon. She suddenly hit the plaintiff, Mr. John, who was on the road as his car had broken down and was waving for help. Aminah was driving at 100 km per hour and was hurrying home at the time because her 4-year-old son was crying in the back seat due to serious stomachache. This court is now in session.
Akqilah Binti Shariff, I'll be your timekeeper for today. Such counsel will be given 2 minutes to present the argument. So for the first counsel for plaintiff, your 2 minutes starts now.
Your Honour, may it please the Honourable Court. My name is Najib, together with my co-counsel Amylia Natrah, representing the plaintiff Mr. John in this court proceeding. Today, the plaintiff would like to bring forward 3 grounds of contention to be addressed before the court. Your Honour, if it please the court, I will begin with my submission. Amirul. Your Honour, we submitted that Aminah had violated traffic laws and caused an accident to Mr. John. According to Malaysia Road Transport Act, the speed limit for a car on the highway is 110 km per hour maximum for right lane, while for the left lane, the speed limit is 90 km per hour. Also refer to the case of Granny Winnie and Mamat. In this case, the plaintiff Mamat drove his car on 80 km per hour at the zebra crossing road and it exceeded the speed limit at that area. Your Honour, applying to our scenario, even though the speed limit at Duke Highway is 110 km per hour, but looking at the matter of the fact where Aminah was arguably speeding on the left lane and not on the right lane of the road, we contend as such because given the fact that Mr. John's car broke down and in normal and usual circumstances, the broke down cars will be parked on the left side of the road as it's specified for emergency situation. It implies that Aminah was driving on the left side of the road as it near emergency lane and she should not have above the speed. Was in emergency situation and she needed to be fast. She should drive on the right lane and not at the left lane, which is specified for below 90 km per hour. Hence, we submitted that Aminah was exceeding the speed limit and violated the traffic laws.
Sorry, your 2 minutes up. You now may proceed to the second counsel.
I will leave to my second counsel to proceed with remaining submission.
Can I start now? As the timer already?
Yes.
Okay. Your Honour, if it pleases the Honourable Court, I am Amylia Natrah, the second counsel, will be submitting the third and fourth grounds on the part of the plaintiff. Your Honour, the third ground is the defendant collided with a visible and distinct vehicle that belongs to the plaintiff. It was mentioned in the precedent case of Granny, Winnie and Mamat. The accident caused by Mamat occurred on a sunny afternoon when Mamat suffered from no disruption of eyesight while he was driving. The court held that the defendant was held liable for hitting the plaintiff on a day with clear weather. As per our current case, Aminah had no excuse to say that she failed to notice a broken down car on the road, given that she was also driving in good weather, similar to the situation in the precedent case. This can also be supported by the fact that Mr. John attempted to make himself and his vehicle visible by frantically waving his hands to alert the drivers on the road of his existence. Hence, Aminah should be liable for hitting Mr. John in broad daylight when she should have been able to avoid the accident. Your Honour, allow me to continue with the fourth ground whereby the defendant collided into the plaintiff who was lawfully positioned on the road. Comparing the issue to the precedent, the defendant hit the plaintiff who was lawfully crossing the zebra crossing. The court held that he was liable for negligence despite the defendant claiming that the plaintiff was at fault for crossing the zebra crossing later than she ought to. Similarly, Mr. John, whose car had broken down, was an inevitable accident and does not put him in an unlawful position on the road. It would be unfair and unreasonable to claim as such because vehicles breaking down on the road is a common traffic issue known by the public and it is unprecedented. Hence, Aminah should have been able to expect such traffic issues to occur on the road the same way Mamat was expected to be careful near zebra crossings regardless of the act of Granny Winnie. For these reasons, I urge the decision of the court to be favourable towards the plaintiff. Your Honour, if there are no further questions, I conclude my submission.
So now we may proceed to the first counsel for defendant. Your 2 minutes starts now.
Thank you, timekeeper. Young Arif, if it pleases this honourable court, I am Myrra Binti Abdul Jalal, representing the defendant as the first counsel. Yang Arif, we have 3 grounds of contention to present in our submission today. First, the plaintiff was not being a responsible highway user. Second, unorthodox circumstances were caused by the plaintiff. And third, there was an urgent medical emergency. I shall require 2 minutes of the court's time for my submission, while my co-counsel require another 2 minutes, and we would like to reserve 1 minute for rebuttals. The defendant submits the first ground of the plaintiff's irresponsible conduct as a highway user, and we posit the issue of whether Mr. John was using the highway lawfully. And to answer this question, we must assess whether Mr. John had abided by the road laws provided in Malaysia at the time of the accident. So in the precedent case of Granny Winnie and Mamat, the plaintiff was lawfully using the zebra crossing, whereas the defendant, Mamat, was affirmatively proven to not have been a responsible driver as he was using his phone and driving simultaneously, which is an illegal act according to Section 17A in the Road Traffic Rules 1959. While Granny Winnie was rightfully and lawfully using the zebra crossing and abided by the Malaysian road laws, the same cannot be said for Mr. John's conduct. And relating this case to our current case, the plaintiff, Mr. John, was not being a responsible highway user as he was in breach of 2 provisions, namely Section 48, subsection 1 of the Road Transport Act 1987 regarding the obstruction by vehicle on road, and Rule 101 A subsection 1 LN 170/59 of road traffic rules regarding whether it is an offence for drivers to not bring a hazard triangle. The defendant raises that even though Mr. John could not have reasonably foreseen that his car would break down, he still has a duty as a reasonable driver to check that his car, before deciding to use it on a highway, was in good condition. If I can be of no further assistance to this honourable court, I shall yield the floor to my co-counsel to proceed with the respondent's remaining submission, and I thank the court for its time and indulgence.
Second counsel, may proceed.
Thank you, my co-counsel, Yang Arif. If it pleases this honourable court, I am Tengku representing the defendant as a second counsel. So I will continue with the next 2 minutes of my submission on the second and third grounds of unorthodox circumstances caused by the plaintiff and also the urgent medical emergency. For the second ground, it must be weighed whether it was reasonably anticipated that Mr. John's car would stop in the middle of the Duke Highway. Generally, they shall not be stopping at the highway unless a car breakdowns. However, when such incident occurs, a hazard triangle should be used. In this current case, Mr. John was not using his hazard triangle when his car broke down in the middle of the highway. Thus, the reasonable standard of duty of care as a highway user was not sufficiently met by Mr. John to alert other road users of the risk imposed by his car. Moving forward, the third ground of urgent medical emergency is submitted due to the Amina's 4-year-old child's serious stomach ache. The wording used in material facts, coupled with the child's young age and Amina's urgent need to drive beyond the speed limit, prove that the condition or illness experienced by the child at the material time was extremely painful and could have led to serious consequences, maybe even death, if Amina had not attended to her child immediately, while Section 42 of the Transport Act makes it an offence to drive in a reckless and inconsiderate manner. Amina should be excused of such provision on the ground that she was attending an urgent medical emergency. So the Duke speed limit is actually 90. First counsel, please check your facts correctly because the Duke is 90, not 110 kilometer. Hence, if we submit the defendant, Amina shall be absolved from the liability of the alleged claims submitted by the plaintiff on the 3 grounds presented. If I can be of no further assistance to this honourable court, I shall yield the floor to my co-counsel to proceed with the respondent remaining submission, and I thank the court for its time and indulgence. Thank you.
Thank you. So now we are done with the arguments. Now we may proceed to the rebuttals part, where each party will be given 1 minute to rebut the arguments given. So plaintiffs, you may start now.
I will rebut the defendant's counsel argument on the hazard issue. For the court's information, according to the Road Traffic Rules 1959, hazard triangle are not compulsory a vehicle. It's only mandatory for commercial vehicles which either carry goods or receive fares. Even so, the plaintiff did give an effort by frantically waving his hand to alert the drivers of his mishap. Secondly, Your Honour, the defendant is contending that the car broke down in the middle of the road. Usually, when a car is about to break down or has already broken down, the driver is able to pull out of the traffic lane. It is reasonably arguable that the plaintiff managed to stop his car in the emergency emergency lane, which is designed area for broken down vehicles. Even if he's unable to do so, liability depends on his action and whether he had taken any effort to alert the drivers, which he did by waving his hand frantically. Thirdly, they submitted that Aminah was in a medical emergency. However, it is still does not allow her to violate the law when there are actions that she should have acted upon in an emergency. Even in medical emergency, she should have used the right lane to match her speed and not the left lane.
Your
That
1
resulted
minute has
in her
ended.
crashing into plaintiff car on the emergency lane as she was speeding. That's all from me. Thank you.
So proceed with the defendant. The 1 minute starts now.
Thank you. So the defendant will be rebutting all three grounds submitted by the plaintiff. First, Aminah was driving beyond the speed limit on the left lane. It cannot simply be presumed that Mr. John's car was parked on the left side as the material facts did not state so. Even so, it does not absolve Mr. John's duty to erect a hazard triangle to alert oncoming cars. Second, the contention that the weather was clear and thus Aminah could have seen Mr. John's visible car. If the plaintiff can assume that the defendant should have been able to see the plaintiff's car, then the defendant can similarly presume that the sunny and extremely bright weather had impaired Aminah's vision. So it is immaterial whether Mr. John's car was visible or not. A reasonable and ordinary man would not anticipate a car to be stationary at a highway where moving cars at high speeds are the norm. Third, the contention that Mr. John was lawfully on the road. We submit a rebuttal that Mr. John was in breach of Malaysian road laws per our first ground, which the plaintiff had clearly neglected. The plaintiff claims that cars frequently break down on highways. This heightens the plaintiff's duty to guard against such a norm. Since it is normal, it should be anticipated and the plaintiff should have been prepared with the right tools to mitigate the risk of obstruction by his vehicle on the road. That is all. Thank you.
Thank you. Exactly 1 minute. So the rebuttals part are done.
Thank you, all counsel, for the submission and the rebuttal. Now the court will adjourn to the next trial date, 2nd December 2022. The court now dismissed.